J.P. Cohen, Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. And God save the United States of America and the state of Florida and this honorable court. Please be seated.
Good morning. Welcome to a session of the 5th District Court of Appeal. I'm Judge Cohen. I'm originally from Orange County, as introduced. To my right, we've got Judge Palmer from Volusia County. To my left, Judge Berger from St. Johns County. If anyone has any electronic phones or other electronic devices or anything that would make any noise and be distracting, if you please turn it off at this point so as not to distract the lawyers during the course of their oral arguments. We've got 3 cases on the docket this morning, 1 criminal, 2 civil cases. On the criminal case, the parties will be allowed 15 minutes per side. On the 2 civil cases, 20 minutes per side. We are going to alter the docket somewhat. We're going to leave the SAYLOR case first, but then we are going to do the Richardson case second, and then we're going to have a change of panel on the Melendez case. So that case will go third. Are we ready to proceed on the SAYLOR case?
We are.
All right. And would you like some time, Mr. Pinnell, for rebuttal?
Please reserve 3 minutes of my time for rebuttal. May it please the court, my name is William Pinnell and I represent Daniel SAYLOR, the appellant in this case. In this case, it was alleged that Mr. SAYLOR committed the offense of perjury during the trial of Scott Bush, who was charged with committing sexual offenses against his 2 daughters. At the conclusion of the Scott Bush trial, Mr. Bush was convicted of sexual battery, lewd or lascivious molestation, and simple battery. This court should reverse the trial court's decision to deny Mr. SAYLOR's motion to dismiss because his statements at Mr. Bush's trial were not material, but were simply statements of opinion or belief. The case law makes it clear that statements alleged to be perjury must be one of fact and not of opinion or belief, and that for purposes of a perjury charge, the testimony should not be considered in isolation, but in the context of the entire case.
In order to be material, the statement has to be germane to the inquiry. It has to have a bearing on the determination of the underlying case. And to the extent that the Bush case was, and as my understanding, is basically a he said, she said, there wasn't any, I don't believe, physical evidence. It came down to the credibility of the witnesses. So why wouldn't this statement that was made by Mr. SAYLOR regarding the dismissal, or we were told to not go forward or dismiss the charges, go directly to the credibility of the victim in the underlying case?
Your Honor, I think there's 2 parts to the materiality argument that we have. One being what you're referencing to, whether it's germane to the credibility. And it's our position that the testimony in question about the Orange County Sheriff's Office and the State Attorney's Office recommending the charges be dismissed doesn't really bear on the credibility of the victims. Because there's a variety of reasons why charges could be not proceeded on. It's not really a direct comment on their credibility. It's really a comment on what the agencies did.
But it certainly could be interpreted that way, couldn't it?
I think under some circumstances, it could be interpreted that way. The SAYLOR case from this court in 1996 said there had to be not all the issues of credibility are material. In that case, they found the fact that
why else would they have admitted that in the trial? I mean,
that was the purpose of the defense counsel. I agree. I'm more focused on the idea that it was Mr. SAYLOR's opinion and a belief as to why it wasn't material.
Which of those 2? Because it doesn't seem to me that it's an opinion. The statement is they recommended to drop the charges. That doesn't sound like an opinion to me. That sounds more like a fact.
The language used by Mr. Saylor is not couched in any terms of opinion or belief. I would agree with the court on that. It's the entire circumstances of the testimony. Earlier, before he made the statement, he said he was not personally involved in the investigation, and by definition, because he was the Windermere Police Chief, he was not in charge of the Orange County Sheriff's Office or the State Attorney's Office. So, by definition, the only way he would know whether they recommended that charges be proceeded on would be someone else told him. He wouldn't know personally because he didn't make that decision if it was made by the State Attorney's Office or the Sheriff's Office. It would be a belief.
The jury could find that wasn't true at all, that he testified in that fashion to help his friend in an attempt to have his friend acquitted.
But of course, the jury can make that determination, but right now, we're talking about materiality, which is a pretrial determination by the judge. It's an issue that actually the jury is not asked to determine. So by definition, his testimony that those agents...
There was no other evidence that someone else had told him that other than, the argument that you're making, correct?
Well, my argument is by definition, he's not in charge of those two agencies. So for him to know whether they recommended charges, he would have to learn that from someone else. So it would be a belief, not his personal opinion, as in a situation where he was an eyewitness to something. That would be his personal belief, that would be his own observation, and if he stated a fact about that, that would be subject to perjury, as opposed to something he was told about a decision by another agency.
Necessarily true. I mean, as a law enforcement agent, you could get a document from the State Attorney's Office, a declination of prosecution. You could get any number of documents that would lead you to know firsthand the assertion that the charges had been...
That would still, it's our position that would still be his belief, but about what they recommended. But I'll move on to the other issues. It's our position that this court should also reverse Mr. Saylor's conviction because he was not provided with a fair trial. One, the prosecutor violated the trial court's order in limine by implying that Mr. Saylor's testimony resulted in a not guilty verdict in the Scott Bush case. Two, the jury was improperly instructed. Three, irrelevant evidence was introduced by the state. And four, the trial judge improperly commented on the weight of the evidence against Mr. Saylor. Prior to trial, the trial court granted the state's motion in limine to preclude mention of the actual verdict in the Scott Bush case. But during closing argument, the prosecutor said, there's a reason he couldn't say that, because he couldn't testify on the stand for his friend Scott Bush. That's what he thought, because if he was going to convince the jury of people that these little girls were lying, he had to be definitive, and lo and behold, he was.
He was definitive, or he was convincing the jury?
Your Honor, it implies that he was successful in convincing the jury. I think you could argue it...
Couldn't it also simply mean he was successful in arguing it definitively?
I think the term lo and behold, which is kind of a phrase used by the prosecutor, lo and behold, surprise, he was, suggests that he was successful in convincing the jury. I don't think there's I think it's a reasonable conclusion that he was successful in convincing the jury by his definitive statement. He had to be definitive in order to convince them, and lo and behold, he was. So it's certainly susceptible to the conclusion that he was, which is improper because it suggested to the jury that his testimony resulted in an alleged child molester being acquitted, and it was also factually incorrect.
Tell me the statement that leads into the lo and behold statement.
Because if he was going to convince a jury of people that these little girls were lying, he had to be definitive, and lo and behold, he was.
He was what? Definitive?
And he had to be definitive in order to convince a jury.
And he was what?
Successful. No, he was.
He was what? It wasn't he was the jury convicted. The only grammatical part of it that would make sense is he was definitive.
I think in the entire context, Your Honor, it suggests he was successful.
Well, if he was successful, then the defendant below would have been acquitted, and that wasn't the case.
Correct. And it's prejudicial to him for the jury to think that his testimony was successful in acquitting an alleged child molester. That's the prejudice to Mr. Saylor here.
Right, so your suggestion is that the prosecutor in the opening, in that comment, in the closing argument, it wasn't disclosing the verdict. In your argument, it's disclosing what wasn't the verdict, which is an acquittal.
It's a comment, right, correct. It's a comment on a verdict that was incorrect, correct. But suggested that the verdict was not guilty and that his testimony had the impact of having an alleged child molester be found not guilty.
Was that objected to?
Your Honor, it was objected to. It was objected to, it was overruled. So it's preserved for appeal here today. It's our position the court should either granted a mistrial, or should have sustained the objection and either granted a mistrial or given a curative instruction. Because the objection was overruled, neither one of those things happened. It's also our position that the jury instruction provided on the elements of perjury, specifically on the issue of materiality, was improper and constituted fundamental error. After providing the elements of the alleged offense of perjury to the jury, the court told the jury, the law requires the judge to decide if the alleged statement is material, and I have decided that it is material. Therefore, you will not further concern yourself with this issue. It's our position that this...
Part of the standard jury instruction with an if applicable intro,
It is, Your Honor.
Is it your position that it would never be applicable and therefore it's always wrong to give it, or for some reason there's something about this case that makes it inapplicable here?
It appears to me that it would never be applicable since the Florida Supreme Court has now held that materiality is a threshold issue to be determined before trial by a trial judge. So if it's not supposed to be addressed at trial, then there's no reason to give the instruction. And the fact that it's a standard instruction doesn't...
But there's also an instruction that says knowledge of the materiality of the statement is not an element of the crime.
Sure.
Wouldn't the jury need to be instructed as to that?
I guess if there was a defense, but it seems like under the Ellis case that wouldn't be a permissible defense because, or that would need to be raised pre-trial, because materiality under the Ellis case is a threshold issue before trial, like probable cause, like the admissibility of a confession, or admissibility of evidence, or the legality of a search or seizure. Those are never addressed at trial. Those are always addressed pre-trial, so they have no place in the instructions.
All right, by arguing that it was his opinion, not a statement of fact, aren't you indirectly arguing that it wasn't material?
I'm arguing that it was his opinion, yes, but that was at the pre-trial ruling, not a trial. So that was his argument to dismiss pre-trial. It wasn't argued at trial that it was his opinion. It's argued pre-trial that that's why it wasn't material. And either way, the judge has just told the jury that she made a pre-trial finding of fact that it was material. He's supposed to be presumed innocent. Before the deliberation started, the judge has already told the jury that she's made a finding in support of the state and against Mr. SAYLOR.
Well, because one element has been established by whatever means, that doesn't affect the presumption of innocence, does it?
I think it does, Your Honor.
The parties could stipulate to one of the elements of any given crime, right? And the jury can be told, there's 4 elements here, you only have to consider 3 of them.
Of course they could, and they did in this case that he was under oath. But there was no stipulation on materiality in this case, and again, materiality is not an element, so the jury, the instruction should never even been given.
Materiality isn't an element?
It's not. It's a pretrial determination. It's not an element of the offense.
It's not an element for the jury to determine, but it's one of the elements of the crime, right?
Right, it's not an element for the jury to consider. Sure.
Under oath is an element of the crime.
Correct.
In this case, that was not an issue for the jury, right?
Because it was stipulated to.
Okay, because for some legal reason, the jury doesn't have to decide it. Do you tell the jury that they've agreed to that, or do you not mention it because they're not supposed to consider it?
You tell them that because it's an element that's supposed to go to the jury. Materiality is never supposed to go to the jury, and the state agrees with that it would not have been inappropriate to take that language out. There's a clear distinction between an element that the jury is supposed to consider under oath and an issue that's a pretrial determination by a judge. It shouldn't be mentioned. It's the equivalent of probable cause.
Was that objected to?
I'm sorry, that was not objected to.
All right, so the question then becomes, if error, was it fundamental error, and what is your argument as to why this goes to the essence of the case?
It's because of the unique role of the trial judge, Your Honor. The trial judge, unlike the litigants, controls the case and has a higher role, as indicated by this court in Johnson. The court says the dominant position occupied by a judge in a trial of a cause before a jury is such that his remarks or comments especially as they relate to the proceedings before him, overshadow those of the litigants, witnesses, and other court officers. That's the Johnson case from this court. So the judge has a different and unique role, and as this court has indicated many times, the jury takes seriously what the judge tells them. And the judge told them, before they even started deliberating, I found this to be material. I find that it could have affected the Scott Bush verdict. That goes to the heart of the case, just like the Barnes case where they introduced a search warrant. And I reserve the rest of my time for rebuttal.
Right.
Thank you.
Right, okay.
May it please the court, my name is Pam Kohler, I represent the state of Florida in this case. As to the motion and the state's comment during closing argument, if you take it in context, at that point she was talking about the 3 reasons why the statement was a lie and that the defendant knew it. This was number 2 of the 3 reasons. So it clearly was not a statement implying anything, basically the allegation is, I guess, the state was lying, and there was no reason for them to lie. They were basically arguing why the defendant had lied and why he knew it. As far as fundamental error in the jury instruction, materiality is not an element, and it was not in dispute. All the elements were correctly charged in this case. The only issues had to do with elements 4 and 5. And that had to do with that the statement was a lie, and the defendant intended to lie about the statement, and that was all argued by both sides.
Didn't the trial judge have told the jury that this is off the table without making an assertion that I find it to be material?
This is part of the standard jury instruction. I assume that's why the judge followed it. There was no objection when it was included in the jury instructions. I think it basically cancels itself out. It says materiality's out there, but the judge has already decided it. Nobody mentioned materiality during the trial, during closing arguments at any time except for this jury instruction. So I think the jury's just thinking, oh, something legal happened that really didn't involve us. So as long as they were properly instructed on the elements in this offense, which they were, the argument had to do with elements 4 and 5, and that was the whole issue in this case. I don't think that you can actually show fundamental error when you look at the Delva cases, the cases that followed Delva. And then he was talking about the Barnes case. Of course, in the Barnes case, they not only did they introduce the PC affidavit, but then when the jury asked about it, the judge sent a statement back.
What I'm suggesting to you is that it would have been very easy for the trial judge to say the law requires the judge to decide if the alleged statement is material, therefore you will not further concern yourself with this issue, without adding, and I have decided that issue.
And if they had been objected to, perhaps the judge would have. I mean, it's part of the standard jury instruction. Basically, the judges follow the standard jury instructions. If the defense had said, well, Your Honor, that has nothing to do with this case or that's improper, perhaps the judge would have said, you know, you're right. I don't know why I would be saying that, and I'm not going to. But he did not. And again, it's not going to an element of the offense.
Is it any different than, say, in a battery on a law enforcement officer instruction where there's a point in the instruction, I tried to pull it up, I'm having difficulty, where after the testimony, there's, I believe, an instruction where the court says, I now instruct you that an officer from the Orange County Sheriff's Office is a law enforcement officer.
Yes, ma'am, and I looked that exact instruction up, and that's exactly what it says. I mean, the judge isn't allowed to say, Deputy so-and-so is a law enforcement officer, but a judge is allowed to say, by the way, a deputy sheriff at the Orange County Sheriff's Office is a law enforcement officer. So, and that's an element of the offense in battery on Leo or resisting. This is not even an element of the offense. So I think that, I don't see how there can be fundamental error in this case. Here, the statement was obviously material, as this court has found, and several courts has found, when it has to deal with the credibility of witnesses, either to bolster the witness or to impeach the witness, it's considered material. And then finally, the trial court properly admitted the testimony about that there were only 2 victims, and it was only their testimony that as to the criminal actions of Scott Bush, and clearly to show the defendant's motive and to give the jury some context in which all of this is coming about, it was clearly admissible at that point, and not an abuse of discretion. If this court has no further questions, I will rely on my brief and ask you to affirm. Thank you.
Thank you.
Please the court. It's our position that this is the equivalent of the Barnes case where a search warrant was introduced into evidence. It's a prior judicial finding. There's no place for it in a jury instruction. It's a violation of 90.106, which explicitly precludes a judge from commenting on the weight of the evidence. The fact that it was a standard instruction doesn't absolve it from being fundamental error. We've had 3 versions of the manslaughter instruction be found by the Florida Supreme Court to be fundamental error. We've had the self-defense instruction around the state be found to be fundamental error. That doesn't absolve the trial judge of determining whether the instruction is proper. The fact that the element wasn't in dispute at trial doesn't matter here because the problem is that it's the judge commenting on the weight of the evidence. The judge has a unique role in the proceedings and is relied upon by the jury to be in charge of the case and to have the judge explicitly tell them before they start their deliberations that she found that Mr. Saylor's testimony may have affected the outcome of Scott Bush's case, and we're talking about a case with child molestation, is extremely prejudicial. He's presumed innocent, and before deliberations start, the judge is telling the jury, I've already made this finding of fact based on my view of the evidence. It's improper, it's fundamental error. I cite to the Walden case where they found fundamental error from the 4th DCA 2013, where any doubt is raised that an accused was prejudiced by judge's remark, a new trial is warranted. They found fundamental error. This court should found fundamental error based on the court's improper comment on the weight of the evidence. Thank you.
Thank you, sir.